Welcome back, everyone, to the deep dive. Today, we're going to be taking a deep dive into, well, deep dives, actually, specifically the core concepts of cybersecurity risk management and the legal and ethical considerations that surround it.
Right.
So we've got chapters 2 and 3 from CYBOK version 1.0, and, well, we're going to try to distill the most important insights for you without, well, making it a boring textbook reading.
Exactly.
So in chapter 2, we're really drilling down into the nitty-gritty of risk assessment, risk management, and how organizations go about actually governing their approach to cybersecurity threats. Then chapter 3 gets into the legal and ethical considerations, and it's actually quite surprising sometimes how established laws are being applied or even challenged in this whole digital world.
Yeah, it's a fascinating landscape that's constantly evolving. So we're going to try to break down, what really matters for you. And I think one of the most interesting things to start off with is, this concept of risk. We all have this gut feeling about what's risky and what's not. But chapter 2 really pushes us to kind of go deeper and think okay, how do we actually assess and manage these risks in a more systematic way?
Yeah, it's one thing to, have a feeling, but how do you back that up? It's more than just a checklist, right?
Exactly. And one of the key things that the Source 41 emphasizes is, effective risk assessment really hinges on making our assumptions explicit. So it's not enough to say, oh, this new system feels risky. We need to articulate why we feel that way. What are the underlying assumptions that are driving that perception of risk?
Right. You're kind of showing your work, so to speak. Like, okay, I feel this way, but here's the reasoning behind it. But how do we actually move from that initial gut feeling to something more concrete, more measurable?
So the material explains that risk assessment really involves two key things. Gathering observations, so what are we actually seeing happening? And then also our perceptions, like how do we interpret those observations? And the key is that these need to be justified. We can justify our perceptions through logical reasoning, like, okay, if we don't patch this vulnerability, an attacker could potentially exploit it to gain access. Or we can look at past incidents. We can compare our situation to other, similar environments and see what's happened there. So it's really, it's a mix of informed intuition and analytical rigor. You kind of need both.
So it's having that initial feeling and then backing it up, right?
Yeah.
With data, with some sort of argument that holds up. Okay, so we've identified these potential problems, we've backed up our concerns. Now what? What do we do with that information? That's where risk management comes in, right?
Exactly. So risk management is all about what we do with those risks that we've identified. It's the process of developing and evaluating different options to address them. So, do we try to prevent the risk altogether? Do we accept the risk? Maybe it's a low-level risk that we're comfortable living with. Do we try to transfer the risk, maybe through, insurance or outsourcing certain activities? And I think a really critical factor in this evaluation is understanding the risk tolerance of the individual or the organization involved. What level of potential loss are they actually willing to accept?
That's a really important element you bring up, the human element, because what one organization may think is an unacceptable risk, another organization may be like, well, that's just the cost of doing business.
Right, exactly.
And then we get to risk governance, which kind of sounds like the overall scaffolding that holds this whole risk management process together.
Yeah, I think that's a great analogy. Risk governance is really that overarching framework that ensures that risk management is being done effectively and that it's actually aligned with the organization's overall goals and objectives.
Yeah.
And this goes beyond just the technical aspects of IT security. It also includes things like legal compliance, social responsibility, economic considerations. It's really the leadership's role to set the tone and to ensure that, risk is taken seriously at all levels of the organization.
Yeah, it's about embedding that risk awareness into the very DNA of the organization, right?
Exactly.
Now, the source material gets quite practical when it talks about NCSC guidance on component-driven versus system-driven risk management.
Yeah.
What's the key difference there?
This is really useful for thinking about the different scales of cybersecurity challenges that we face. So the component-driven view, as they outline in Figure 2.3, is really best suited when we're looking at individual assets, specific components of a system like a single server or a specific application where the complexity is, relatively well understood and the functionality is very clear. It's like checking the security settings on your laptop.
Okay.
It's very focused, very granular.
Yeah, it's kind of contained, right?
Yeah.
But when do we use the system view? When is that more appropriate?
So the system view comes into play when we're dealing with much more complex scenarios, especially in the early stages of development or when you have multiple systems interacting in very complex ways. It's about trying to understand the broader landscape of risks before you've even, finalized the physical implementation. And this is really crucial for facilitating discussions among different stakeholders because you might have different people with different perspectives on the system and its potential vulnerabilities. So imagine, you're designing the security for an entire hospital network. You need to consider all the different interconnected devices, all the different systems. You can't just look at one component in isolation.
Yeah, I mean, one vulnerable component in a larger system can bring the whole thing down, right?
That's exactly. And the source highlights that, the importance of these different levels of risk really varies depending on where you sit within the organization. So for an operational employee, the risk to their specific component that they rely on every day to do their job, that's paramount. If their workstation is compromised, they can't work. But, for a higher level manager or an executive, they're more concerned with the overall risk to the system as a whole, the potential strategic impact of a major breach. CEO might not be too worried about a single phishing incident, but a widespread ransomware attack that cripples the entire company, that's a different story.
And then it's bridging that gap, right?
Yeah.
Between, the IT guy who's worried about his particular, system and this CEO who's looking at the bigger picture. How do you get everybody on the same page?
Exactly. I mean, the ultimate goal is to develop this kind of unified view of risk, to have a cohesive risk management policy that everybody understands and adheres to across the organization. It's about aligning those different perspectives to really create a strong and resilient security posture. So whether you're focused on securing, a single device or an entire network, understanding these component and system level views is, it's really fundamental.
All right, well, let's switch gears now and move on to Chapter 3.
Okay.
This is where we delve into the world of law and ethics in cyberspace.
Oh, yeah.
And right off the bat, the chapter makes a distinction between substantive and procedural law. Why start with that? Why is substantive law the emphasis here?
Well, the source really emphasizes substantive law because that's the part of the law that actually deals with the core obligations, responsibilities, and behaviors within cyberspace. So this is about things like what actually constitutes cybercrime, what are the legal requirements for data protection, how are contracts enforced online. It's the what of the legal rules in the digital world.
So it's the rules of the road for cyberspace, essentially.
Exactly.
Okay, well, what is procedural law then?
So procedural law, on the other hand, is more about the how. It governs the process of how legal disputes are actually resolved and how individuals interact with state authorities. So this includes things like rules of evidence, court procedures, the steps involved in a criminal investigation. And the source points out that these procedural rules, they tend to be very specific to individual jurisdictions and legal systems. So what's standard practice in a court in one country might be completely different in another country.
Yeah, and trying to, encompass all of those local variations in a global discussion like this. I mean, that would be a whole nother deep dive, wouldn't it?
Yeah.
And frankly, if you need to know that stuff, you probably need to talk to a lawyer anyway, right?
Exactly. You need that local legal counsel to guide you through those specifics. Now, the chapter goes on to talk about the role of legal precedent, and it highlights this really key difference between common law and civil law systems. Maybe you can kind of, elaborate on that a bit.
Sure. So in common law systems like those in the United States and the UK, the decisions that have been made in previous court cases, these are called precedents. They're super influential. So judges in future cases that deal with similar issues, they're going to look back at those past rulings for guidance. And often they're actually bound by those decisions. So it's the system of law that kind of evolves organically through judicial decisions. It's the courts making the law, in a sense. Whereas in civil law systems, which are common in many countries in continental Europe, they place more emphasis on these codified statutes. These are like the written laws that are passed by legislatures. So it's less about building on previous court decisions and more about having this kind of fixed set of rules. Now, that doesn't mean that judicial decisions aren't important in civil law systems. They still are, but there's often more weight given to the opinions of legal scholars. So, when courts are trying to interpret the law, they might look to what legal academics have written about it to help guide their understanding.
That's a fascinating distinction. So common law is more about building on what courts have decided in the past, while civil law is more about sticking to the written rules and, having that scholarly interpretation play a bigger role.
Right. Exactly. Now, when the internet first kind of took off, exploded onto the scene, there was all this uncertainty about how existing laws would apply to this new domain. What were some of the initial perspectives on this?
Well, the Source 97 actually outlines two main schools of thought. One, which was a more radical view, argued that cyberspace was just so fundamentally different from anything we'd seen before.
Hmm.
There are no physical borders. It operates at an unprecedented speed and scale
Right.
that existing legal frameworks were just inadequate. They couldn't handle it. And so proponents of this view felt that we needed to basically start from scratch, like throw out the old rule book and develop entirely new legal doctrines just for cyberspace.
Yeah.
And some even went so far as to question whether nation states even had the authority to enforce laws online.
Wow. So that's a pretty libertarian view of the internet back then.
It really was the Wild West of the internet.
The Wild West, exactly. But what was the other side of that argument? What did the more moderate folks think?
So the more moderate perspective acknowledged that, yeah, there are unique challenges that come with cyberspace, but they argued that, the core principles of existing legal frameworks could be adapted and applied to online activities. It wasn't about throwing out centuries of legal thought. It was about being creative and interpreting and applying those principles to this new context.
That makes sense. I mean, trying to rewrite, uh, you know, the entire legal system for the internet just seems like an insurmountable task.
Yeah, it really does.
So, the chapter then digs into the concept of jurisdiction. This is obviously a huge issue when we're talking about cybercrime because it often crosses international borders.
Absolutely. A crime could be committed in one country, a perpetrator might be in another country, the victim might be in a third country,
Right.
and the servers that were used might be located in a fourth country. So it gets very complicated.
So how do you even begin to untangle that mess?
Well, the source talks about this concept of prescriptive jurisdiction in the context of computer crime. And this basically means that a state has the power to apply its laws to certain activities, even if those activities take place outside of its physical territory. So many countries have written their cybercrime laws specifically to cover actions that target their citizens, their infrastructure, their interests, regardless of where the perpetrator is physically located. So,
Right.
for example, if somebody in, let's say, Russia launches a ransomware attack against a hospital in the United States, the U.S. would argue that it has jurisdiction to prosecute that attacker, even though they were never physically present in the U.S.
So basically, a country can say, if you attack us online, we can come after you legally, even if you're not physically in our country.
Exactly. And it goes both ways. If someone in the U.S. launches an attack against targets in another country, the U.S. might also have jurisdiction over that person.
Right, because the crime originated on U.S. soil, so to speak.
Exactly. And public international law recognizes this. They say that states have sovereignty over their territory, and they have the right to protect their interests. And that includes their digital interests.
Makes sense. Every nation has an interest in protecting its own digital assets. Now, speaking of protecting things, privacy is a fundamental right in many parts of the world. How does that play out in the digital sphere?
So privacy is recognized as a fundamental human right, though it's not absolute. International agreements like the Universal Declaration of Human Rights and the European Convention on Human Rights, they both enshrine the right to privacy. However, they also acknowledge that there can be legitimate reasons for interfering with that right. But those reasons have to be lawful. They have to be necessary. They have to be proportionate. So, for example, law enforcement might be allowed to access private communications if they have a warrant and they're investigating a serious crime.
So it's a balancing act. You have to balance the individual's right to privacy against the state's need to ensure security and enforce the law. And of course, all of this gets even more complicated with the rise of things like, virtual communication service providers, think WhatsApp, Zoom, these kinds of things.
Right, these are often called over-the-top providers, and they create a real jurisdictional headache because they operate across borders. They don't necessarily have a physical presence in every country where their users are located.
Right.
And so the general principle is that these providers are subject to the jurisdictions of the states where their service is actually being supplied, meaning where the users are. But actually enforcing that can be quite difficult.
Right, because you have these companies that are based in one country. Their servers might be in another country, but their users are all over the world.
Exactly. And different states have taken different approaches to this. Some try to issue orders for lawful interception so they can get access to communications data. Others have even considered sanctions, like blocking access to services that don't comply with their laws. It's a very evolving area of law.
It really is the Wild West out there in some way.
Yeah, in some ways.
Um, but now let's talk a little bit about data protection, especially in the context of, crime investigation and prevention. Are the rules the same for, say, law enforcement as they are for a private company?
Not necessarily. So the source points out that state practitioners, like law enforcement agencies, often have some reduced obligations under data protection laws when they're processing data for the purpose of crime investigation or prevention. And the idea here is to make their job easier, to make it possible for them to actually investigate crimes and protect public safety.
Right. You don't want to hamstring, law enforcement by having these super strict data protection rules that prevent them from doing their jobs. But what about private companies, though? Like, if a company is trying to prevent fraud, do they have the same leeway?
So private companies are generally subject to the full force of data protection laws, like GDPR in Europe. However, GDPR does recognize that fraud prevention is a legitimate reason for processing personal data. So there's a bit of, wiggle room there. And member states can also create exemptions or reduced obligations for companies that are involved in preventing, investigating, or prosecuting criminal offenses. But those are usually more limited in scope.
So even though they might be trying to achieve the same goal of, preventing crime, the legal frameworks are a little bit different for public versus private
Right,
entities.
exactly.
Okay, let's talk about how contracts can be used to encourage better security standards, especially when you're dealing with supply chains.
Yeah, this is becoming increasingly important as organizations realize that they can't just focus on their own security. They also need to make sure that their suppliers are secure. Because a weak link in the supply chain can create a vulnerability for everyone.
Right, it's like you're only as strong as your weakest link.
Exactly. And so what organizations are doing is they're including specific clauses in their contracts with suppliers that require them to meet certain security standards. This could be adherence to a recognized standard like ISO 27001, or it could be custom security requirements that are specific to the organization. So, a large company might say to a software developer they're hiring, hey, you need to follow these secure coding practices that we've outlined in the contract.
So it's putting those requirements into the legal agreement so that there are actual consequences if they're not met.
Exactly. And these can take different legal forms. They can be warranties, they can be representations, conditions, precedent. There are different ways to structure it legally.
Yeah.
But the key is that you're making it a contractual obligation.
Yeah. Now, the chapter also touches on the distinction between warranties for goods and warranties for services, and this seems particularly relevant in the age of cloud computing.
Yeah, this is a really tricky area. So traditionally, a warranty for goods is all about whether the product meets certain specifications. It doesn't really matter how carefully it was made. It just matters that it works as advertised. Yeah. But a warranty for services is more about whether the service provider exercised reasonable skill and care in providing that service.
Right.
But with cloud computing, it's getting harder and harder to make that distinction.
Yeah, I mean, is cloud storage, is that a product? Is that a service?
Exactly. I mean, are you buying it or are they providing it to you? And this can have really big implications for who's liable if something goes wrong.
Right, because if it's a product, then maybe there's a warranty that says it has to function in a certain way. But if it's a service, then maybe it's more about whether they were negligent in providing that service.
Exactly.
So it's another example of how the law is constantly trying to catch up with technology.
Yeah.
And it's something that, anybody who's operating in this space needs to be aware of. Okay, let's talk about a legal doctrine called negligence per se. This one sounds like it could be really impactful in cybersecurity cases.
Yeah, this is a really interesting one. So negligence per se basically means that if you violate a public law or a widely accepted standard of care, and that violation causes harm to somebody else, then your conduct is automatically considered to be negligent.
Oh, interesting.
You don't even have to prove that you acted unreasonably. The violation itself is enough to establish negligence.
So in the context of cybersecurity, this could be really powerful, right?
Yeah, absolutely. Because if there's a law that says, you have to encrypt sensitive data and you don't encrypt the data and that data gets stolen, you could be held liable for negligence per se because you violated the law. And even if there's not a specific law, but there's a widely accepted industry best practice, like, implementing multi-factor authentication, and you don't do that and you get hacked, a victim might be able to argue that you were negligent per se because you didn't follow that best practice.
So this is a pretty low bar to clear then in terms of establishing negligence.
Potentially, yes. It can be a much easier path to proving negligence than having to go through all the steps of showing that the defendant acted unreasonably under the circumstances.
So this is definitely something that, companies and organizations need to be aware of
Absolutely.
because it could really change the game in terms of liability for cybersecurity incidents. The chapter also mentions that, one of the main purposes of tort law is to compensate victims for harm, but there's this crucial element of causation that has to be proven.
Right. So even if somebody does something negligent, they can only be held liable for the harm that was actually caused by their negligence. There has to be this direct link, this cause and effect relationship between the negligence and the harm.
Makes sense. But how do you actually prove that?
Yeah, that's the tricky part. And this is where the legal concept of but-for causation comes in. The idea is that the harm wouldn't have happened but for the negligent act.
So you have to show that if they hadn't been negligent, the harm wouldn't have occurred.
Exactly. And this can be really challenging in cybersecurity cases because often there's a chain of events.
Yeah.
There's a vulnerability, then there's an exploit, then there's data theft, then there's financial loss. And it can be difficult to prove definitively that a specific security flaw was the direct cause of a specific harm.
Yeah, it's not always a clear line from A to B.
Right.
All right, let's move on to intellectual property rights.
Okay.
The source describes these as negative rights. What does that mean?
So when we say that intellectual property rights are negative rights, we mean that they give the owner the power to prevent other people from doing certain things with their intellectual property. So, for example, if you have a copyright on a piece of software, you can prevent other people from copying that software without your permission.
Okay.
If you have a patent on a particular technology, you can prevent other people from making, using, or selling that technology without your permission. But it's important to understand that owning an IP right doesn't give you unlimited freedom to do whatever you want.
Right. It's not a free-for-all.
Exactly. Your patented technology might still infringe on somebody else's patent, for example. Or you might be restricted by other laws, like competition laws.
So it's more about the power to exclude others, not necessarily a carte blanche to do whatever you want.
Right.
Okay. The chapter also delves into the complexities of software patents. Specifically, it mentions that the U.S. has become more receptive to software patents compared to some other countries.
Yeah, that's an important trend. Historically, some patent systems have been hesitant to grant patents for software, as such, because they view software as more of an abstract idea or a set of instructions rather than a tangible invention. But the U.S. patent system has become more open to software patents over time, and this has both pros and cons for cybersecurity. On one hand, it can incentivize innovation. Companies are more likely to invest in developing new security technologies if they know they can get a patent on them.
Right, they have to protect their investment.
Exactly. But on the other hand, it can lead to this really complex patent landscape where it's hard to know who owns what, and it can lead to more patent litigation, which can stifle innovation in some ways.
Right, so it's a double-edged sword.
Yeah, it is.
The fact that registered IP rights, like trademarks, are often granted on a country-by-country basis also creates challenges in this global digital world.
Absolutely, because if you have different companies that own identical trademarks in different countries, it can lead to all sorts of confusion, especially when those companies start operating internationally or online. Consumers might not know who they're actually dealing with, and it can create legal headaches when, one company tries to expand into a market where another company already has that same trademark.
It's a reminder that, the internet might transcend physical borders, but legal rights don't always.
Yeah.
All right, let's wrap up with digital signatures and identity trust services. Are digital signatures legally recognized in the same way as, traditional handwritten signatures?
In most cases, yes. Many countries have passed laws that specifically say that electronic signatures are just as valid as handwritten signatures for most purposes. And this has been really crucial for facilitating online commerce and communication. You can sign contracts online, you can submit legal documents online, all thanks to these digital signature laws.
Okay, so that makes sense. But what about the companies that actually issue these digital certificates? What are their responsibilities and what kind of liability do they face?
Yeah, so certificate authorities have a really important role to play here because they're the ones who vouch for the identity of the people or organizations that are using those digital certificates. And they can face some pretty serious liability if they mess up.
So if they issue a certificate to the wrong person, or if their systems get hacked and somebody gets a hold of, a fraudulent certificate, what happens then?
Well, they could be held liable for negligence. And this involves looking at things like Did they exercise a reasonable standard of care? Did they take appropriate steps to verify the identity of the person they were issuing the certificate to? Could they have foreseen the harm that might occur if they made a mistake? If a certificate authority doesn't do its due diligence and issues a fraudulent certificate, and that certificate is then used to, impersonate a bank or steal somebody's identity, they could be on the hook for a lot of damages.
So it's a high-stakes game for these certificate authorities.
It really is.
And speaking of regulations, the chapter mentions the EU Cybersecurity Act. What's the role of that?
So the EU Cybersecurity Act is trying to create a more unified approach to cybersecurity certification across the European Union. The goal is to establish common standards and procedures for certifying the security of digital products and services. And this is meant to increase trust. It's meant to give consumers more confidence that the products and services they're using are actually secure.
Right, because right now it's kind of a patchwork of different standards and regulations.
Exactly.
Okay. Lastly, the chapter touches on export controls for security technologies. So this used to be all about, restricting the sale of military-grade weapons and technology. But now it seems like it's expanding to include, things that have both civilian and military uses.
Yeah, these are often called dual-use goods.
Yeah.
And this is a really tricky area because, a lot of security technologies can be used for both good and bad purposes. Encryption is a perfect example. Encryption is essential for protecting our privacy and security online, but it can also be used by criminals to hide their activities.
Right.
And so governments are trying to strike this balance between, allowing for the free flow of technology and innovation while also preventing sensitive technologies from falling into the wrong hands.
And it's a constantly evolving challenge, right?
Yeah.
Because technology is always changing, and the bad guys are always finding new ways to use it for their own purposes.
Yeah.
Okay, so the chapter also addresses the principles of international law when it comes to cyber operations, specifically, operations conducted by one state against another state. And this obviously gets into some very sensitive territory.
Yeah, it really does. So the basic principle under international law is that states are prohibited from using force or the threat of force against each other. And this applies in cyberspace just as it does in the physical world. But of course, things get complicated when you try to define what constitutes use of force in cyberspace.
Right, because it's not like sending tanks across a border.
Exactly. And so there's a lot of debate about, what kinds of cyber operations would actually be considered a use of force that would violate international law. And then there's the question of, okay, if a state is the victim of a cyber attack, what are they allowed to do in response? Do they have the right to retaliate? And if so, how?
And so there's this concept of an armed attack in cyberspace. What does that mean?
So under international law, if a state is the victim of an armed attack, they have the right to defend themselves, and that defense can include using force. But the question is, what level of cyber attack would actually rise to the level of an armed attack? And this is something that legal scholars and policymakers are still debating. Some people argue that a cyber attack that causes significant physical damage or loss of life, like, an attack that shuts down a power grid or disrupts critical infrastructure, that could be considered an armed attack. Others argue that it has to be something more akin to a traditional military attack, something that's intended to cripple a country's military capabilities or to overthrow its government.
Right. It's a really gray area.
It is.
Yeah.
And this is where things like the Talon Manual come in. So the Talon Manual is this document that was drafted by a group of international legal experts, and it's an attempt to apply existing international law to cyber warfare. It's not legally binding, but it's a very influential document.
So it's kind of a guidebook.
Yeah, it's a guidebook for how states should think about these issues. And it's been updated a couple of times, most recently in 2017, to reflect the evolving nature of cyber threats.
So this is a constantly evolving area of law.
Absolutely.
It's really fascinating, but it's also, it's a little bit scary because there's so much uncertainty.
Yeah, it is. And I think that's one of the key takeaways from all of this. Cybersecurity is not just a technical issue, it's also a legal and ethical issue. And the laws and norms are still being developed, so it's important for everyone to be aware of these issues and to be involved in the conversation about how we govern cyberspace.
Absolutely. Well, this has been a fascinating deep dive into chapters 2 and 3 of CYBOK version 1.0.
Yeah.
We've covered a lot of ground, and we've really just scratched the surface. But hopefully, this is giving you a better understanding of the complex interplay between risk management, legal frameworks, ethical considerations, and the constantly evolving world of cybersecurity. And just a reminder to our listeners, this deep dive has really just focused on chapters 2 and 3. We still have a lot more to cover from CYBOK version 1.0, and we'll be getting to that in our next deep dive.
Exactly. We'll be exploring some of the more technical aspects of cybersecurity in the coming episodes, so stay tuned.
In the meantime, we'll leave you with this thought. How do you think the rapid pace of technological change is impacting the development of cybersecurity law and ethics? Are the laws keeping up? Are we doing enough to address the ethical challenges? It's something to think about. Join us next time for more on the deep dive.